Good morning, and thank you for being here. Chris, it's 11 o'clock. Why don't you start us off with some logistical matters, and then we will turn it over to Stacy for our featured presentation today.
Thank you, Vladimir. Thank you, everybody, for joining. For your information, this team's webinar is being recorded and will be posted to the Water Leadership Group website following the conclusion of the webinar. If you do not wish to be recorded, please refrain from enabling your microphone or camera and avoid sharing personal information during this session. Participating in this webinar constitutes your acknowledgement and agreement to these terms. Following the conclusion of the presentation, we'll have a question and answer session. Please post your questions into the chat, and I will pass them over to the moderator when we begin that portion of the webinar. And with that, I'm going to hand it off to our Water Leadership Group Steering Committee member, Stacy LaPierre. Thank you, Stacy.
Hello, everyone. Welcome. And this is our Water Leadership Group webinar on Risk Management Essentials, Limitation of Liability. An important role in risk management is determining insurance requirements in contracting. What is less discussed and equally important is making sure contract language allows for the full access of those insurance requirements. Today, we are discussing the importance of the limitation of liability section in contracting, how it directly impacts access to insurance, and providing some strategies for negotiating this section. Have you ever spent hours reviewing and negotiating a contract to ensure insurance limits were applied, only to find out that when a claim was filed, there was a limitation of liability clause that limited access of insurance, possibly limiting it to as low as $100? That is exactly what we are talking about. What we have found talking to you in our Water Leadership Group is that depending on the size of your water organization, the contract review process often lies within different departments within our organizations, and that there is a need to better understand, communicate, and coordinate our contract reviews, especially with respect to the limitation of liability clause. To unpack this subject for us, we are proud to introduce today's speaker, Noelle McCall, an expert in the field of risk and insurance contracting. Noelle is a national practice leader for contract reviews with the international specialty broker Howden. She has over 20 years of specialized experience in risk management and insurance contracting. She has led the national contract review practices at Marsh and Aon and is a co-founder of the Contract Risk Academy, where she developed industry-recognized tools, insurance requirement templates, and training programs to simplify and streamline the contract review process. Noelle holds a bachelor's degree in contracts and acquisitions with a minor in international business and has been a featured speaker at the Institute's, the Into Risk Conference, RIMS meetings, the Employer Engagement Forum, Marsh, In-House Connect, and Lawline, to name a few. Noelle, thank you for sharing your time with us today. The floor is yours.
Thank you, Stacy, for that warm introduction, and hello, everyone. I'm very excited to be speaking with you today about one of my favorite subjects, limitations of liability. It's funny that the acronym for limitation of liability is also LOL, which is also for laugh out loud. But a lot of it's not so funny. So we'll get into that today. So before I get started, I have to include a mandatory disclaimer. The guidance that I present in this presentation, I present from an insurance and risk-related, not legal perspective, because I'm not a lawyer. Please consult with legal counsel for legal advice on all contract wording. However, I will say I've taught a lot of lawyers. So let's go. For today's agenda, we'll be going over the following. We'll start with an introduction of our 4 learning objectives. We'll look at limitation of liability clauses in a number of different facets. So we'll look at the definition of what that is, the purpose for their use, why they're relevant and important, some limitations on the use for LOLs, different types of LOLs, elements, waivers of consequential damages, direct and indirect damages, and different limitation of liability factors. Next, we'll look at the insurance impact on limitation of liability strategies. Believe it or not, there are strategies with regards to insurance around limitation of liability. We'll round out today's session with a practice session where we will take a very heavily vendor-favored limitation of liability clause, and we will practice de-risking it by making it more of a balanced approach where it's good for both parties, and then look at it where we transfer it into more of a public entity favored clause. And then we'll have a Q&A session, so please bring your questions. I'd love to answer those. So, learning objectives. We do have 4 of them for today. So the first one is we want to understand the impact of LOL clauses on contractual risk. The next one is we're going to learn different types of LOL clauses, some key elements and strategies around those. Our third learning objective for today is to understand the impact of limitation of liability clauses on insurance, as well as indemnity. And then our fourth learning objective is we will practice revising a limitation of liability sample clause to be more in favor of public entities. So let's dig into it. Limitation of liability clauses. Let's start with the definition of liability. What exactly is liability? This is a responsibility to compensate for some failure to perform according to an established stipulation, such as a contract term. What is a limitation of liability? That is a clause in a commercial contract that restricts the amount of compensation that's owed from one party to another in case of performance failure, such as breach of contract. So the definition of limitation of liability clauses includes the following. It limits the liability of one party or both parties for losses, damages, or injuries caused to the other party for breach of contract or other legal issues. Now, this has the effect of capping the financial liability between parties, and that can be one-sided or mutual. So we'll look at that. The purpose of using a limitation of liability clause is to help parties manage risk exposure in contracts. And you do this to ensure predictable financial outcomes for both parties or one party. It's a way to help control costs and control the risk in a contract. Why are limitation of liability clauses relevant? Well, they're often used in service contracts where the damage of scope may be really broad or could be difficult to quantify. Why are these important? Public entities need to understand limitation of liability clauses and how they are used so they can best align them with indemnity and insurance terms and public interests. Here are some key elements of limitation of liability clauses. They serve to cap the liability, so they allocate the risk to protect a business from too much financial exposure or potentially unlimited financial exposure. So contract size, scope of work, and or relative size of the two parties to a contract may guide if, how, and what type of limitation of liability clauses are used. Now, there are direct and indirect liabilities, so we'll take a look at this. We want to clearly understand the difference between these two and which ones may have higher risk than the other. Typically, indirect liabilities can have a broader implication and risk than direct, but it depends on a lot of factors. So more to come on these. We'll take a look at some examples of just what are these two types of liabilities in a bit. Also, carve-outs. Limitations of liability usually exclude some types of claims due to the significant nature of these types of claims relative to the business if these events occurred. Commonly excluded claims include such things like willful misconduct or intentional wrongdoing, gross negligence, IP infringement, data breaches, which can be huge if you can imagine, and indemnity obligations. Some other elements of limitation of liability clauses include the following. The wording should be clear and unambiguous, so there should be no confusion about what the intent of the wording is. They should be clearly written and specify any limits and exclusions or carve-outs in the clause. Oftentimes, you'll want to do things like change the formatting to make these very apparent and noticeable in the contracts. And you can do that by using all caps, underlying the wording, and or putting it in bold type. So it really kind of is in your face when you're looking at the contract and hard to miss. Also, these types of clauses may need to be in separate section all of their own. They should not be buried inside the indemnity or the insurance clauses. Also, both parties to the contract must agree to the terms, so there has to be mutual agreement of this. They need to comply with the law, so the clause needs to comply with all the rules and regulations of whatever state or states or jurisdictions where the work will take place for the project. The Uniform Commercial Code, or CCC, allows terms that limit or exclude consequential damages unless the limitation or exclusion is what's called unconscionable. So what that means is, generally speaking, limitation of liability clauses need to be reasonable and fair. Now, there is a relationship to the indemnity clause. You need to consider when you're drafting the limitation of liability clause how that may impact the indemnification clause or terms. Make sure that any negotiated liability limits don't undermine or conflict with your indemnity terms, or the resulting contract could be unclear, ambiguous, totally unfair, or riskier than expected for one or both parties. These types of clauses can either be mutual or unilateral. So they can be mutual, meaning in both parties' favor, or they can be unilateral or one-sided, only in one party's favor. The company with more risk exposure usually wants a limitation of liability clause only in their favor. And then the company with lower risk exposure may want no limitation of liability, or perhaps make it mutual. Here are some limitation of liability limitations. So these are limitations on the limitations of liability. It's kind of a tongue twister. So these clauses may not be used to limit one party's liability for causing bodily injury or property damage to third parties, such as the general public. You can't agree in a contract that you don't owe any duty of care or anything to third parties that get injured because of something that you do. You can't write that in a contract, otherwise everyone would do it. These clauses also cannot be used to violate public policy, and they can't limit the liability for intentional misconduct or intentional wrongdoing or gross negligence. You do want to make sure to check the state's laws on limitation of liability to see how they do or can apply in the different states and what the limitations are. Now, there are three common types of limitation of liability. Generally speaking, there's financial caps, time limits, and or consequential damage waivers. So we'll take a look at these. The first one, cap on damages. You can add in the limitation of liability a limit on the maximum amount of damages that one party can claim from the other. This could be either a fixed amount, such as a specific dollar amount, or it could be a multiple of fees paid under a contract. So for example, the limitation of liability might say the total liability of party A shall not exceed 1 million under the contract. Time limits. This is a second type of limitation of liability. And you can have one, two, or all three of these in the clause. So keep that in mind. So time limits sets a time frame during which the claims have to be brought. And after the specified period, any right to claim damages may be forfeited. So an example of that is all claims must be brought within 12 months of the loss. So that's type 2. The third one is consequential damage waivers. And these are clauses that exclude liability for things like consequential or indirect damages, such as business interruption costs or lost profits. An example of that would be neither party shall be liable for any consequential damages arising from breach of contract. So what are consequential damages? That's kind of a long term. This is a type of, or these are indirect losses that occur as a result of a breach of contract, but they're not the direct cost of fixing the problem. That would be the direct losses. So what's a waiver of consequential damages? This is a form of an LOL and a contract clause where one or both sides agree that if something goes wrong, they will not claim those indirect losses from the other party. So here's a handy chart that I put together to give you some examples of what I mean by direct versus indirect losses or damages. So the column to the left, we have direct damages, and that's compensation for value directly lost due to a breach of contract and losses arising out of the vendor's performance. That can include things like bodily injury and property damage to others that come about or are caused because of the vendor's operations. It can include the cost to hire another contractor to either finish or correct the vendor's work. Also, wages paid to workers because of a project delay. That's another example of a direct damage. Expenses for materials that are a direct result of delay in the project schedule. So over time, the project was delayed, the cost of goods went up. Think of the tariffs nowadays. The cost of goods is going up all over the place. That's an example. And then the customer's direct financial loss from having to extend a construction loan due to a project delay. On the other hand, indirect damages. These can be pretty much unlimited, by the way, because there's kind of no end to indirect damages when you think about it. These are indirect losses that arise from a vendor's breach of contract or other event. Can include things like loss of profits, loss of customers, penalties, fines, loss of future business opportunities, additional costs due to business interruptions, punitive damages, lost rental income, additional administrative costs, diminution of value, where things go down in value over time, financing costs, rental expenses, and also damage to reputations or loss of goodwill. Now we'll take a look at a sample mutual waiver of consequential damages. So I'll go through the language and then we'll look at some of the key features of this. So waiver of consequential damages to the fullest extent permitted by law. Each party waives any claim against the other for consequential, incidental, or indirect damages arising out of or related to this agreement. This waiver includes, but is not limited to, loss of use, loss of profits, loss of business opportunities, or loss of revenue, regardless of whether such damages were foreseeable, or whether each party was advised of the possibility of such damages. So there's 4 key features I want to point out here. One is the wording "to the fullest extent permitted by law." That's included for enforceability. This is a form of what I would call, the legal term is a savings clause. So it allows the clause to apply to the fullest extent allowed by law. Mutual waiver. The way this is written, where one party agrees to waive against the other, this waiver is applicable to both parties, so it's mutual. This is also pretty broad coverage when you're talking about it, because it has a long list of indirect damages included, including things like loss of profits. And then there's a foreseeability disclaimer included, which means that this clause applies even if the damages were predictable. Now, there are a bunch of factors to consider when you're drafting and negotiating limitation of liability clauses. Here are some of them. First of all, you want to remember that LOL clauses are not one size fits all. They need to be tailored to each contract and what's going on with the scope of work and the type of vendor and all of that. Please avoid copy pasting from other contracts. I know it's a great temptation, and oftentimes it's easier to use old language, but when it comes to LOL clauses, they need to be customized for each contract. You do want to consider the level of risk involved and the potential impact of damage or loss if that could happen. Also, think about your risk appetite as a public entity. What are you willing to accept with regards to LOL terms? Think also about the financial size and resources of the contracting party. So, for example, when you're contracting with a larger, more financially stable vendor, I would suggest pushing for higher limitation of liability cap or limit, or none at all. That would be best. For smaller vendors, you may need to accept an LOL cap. Make sure you add carve-outs for insurance and indemnity so that their insurance can still apply to the full extent. Some additional factors are the following. Think about the broader extent of your relationship with that vendor, the other party. If this is a vendor that you're in a long-term strategic business relationship with them, consider using a more collaborative approach when negotiating. So you could do things like focus on ways to reduce risk for both parties rather than just limiting liability. Some ways to do that include developing contingency plans for use when things go wrong, sharing information about your risk management practices for the benefit of both parties, and maybe conducting joint risk assessments. Some other factors to consider when you're drafting and negotiating these clauses. Successfully negotiating LOL clauses in contracts with vendors requires a careful balance of risk and reward. So it's kind of, I picture a teeter-totter, if you remember those from when you were a kid. You kind of try to balance the risk on one end with the reward, if possible. A best practice is to focus on each vendor's financial strength, size, and their business relationship with your public entity when you're negotiating terms to help maximize protection for your organization while still preserving the benefits of the contract. Here's a pro tip for you. I'd suggest having an early meeting with the vendor to help explain why public entities can't agree to certain conditions. That may be helpful to you. Now we're going to take a look at the insurance impact on limitation of liability strategies. And we have 5 of them, 5 strategies that we're going to go over. We're going to start out with the most protective to public entities and then go towards things that are not as protective that you may need to do. Strategy number 1, just don't have a limitation of liability clause in favor of the vendor. By refusing the LOL clauses that favor vendors, it helps protect your public agency by ensuring vendors are fully liable for the damages that they cause. This is also a really good strategy for high risk or high value contracts that have the potential to have very high damages. So think about the potential risk of loss and the potential high or low severity of the loss if that should occur. Also, promote accountability. Having no limitation of liability sets a strong precedence for requiring accountability and effective risk management of that vendor. Here are a couple more pro tips for you. Start the negotiations with your own contract template. If you start with the vendor's template, it's automatically going to be written in their favor, and chances are they'll already include a limitation of liability cap in it. So start with your own if you can. Require vendors to submit their template exceptions with their bids. And for projects that are over 150,000, mention that adding a limitation of liability would perhaps make it an unlevel playing field with the other vendors who are bidding. Strategy number 2, add a mutual waiver of consequential damages instead of a full limitation of liability. This can result in a balanced risk management approach because you're waiving consequential damages for each party, so each party has that protection. The mutual waiver excludes indirect damages, but it preserves responsibility for direct damages. Therefore, it helps to balance the risk fairly. Also, vendor acceptability. The waiver approach often makes it more agreeable to the vendors, which helps out with your contract negotiations. And then public agency considerations. You need to ensure that critical damages related to operations are not excluded in the waiver. So, for example, if you're hiring a vendor to do repair a roof on a public building, then you don't want an exclusion on behalf of the vendor saying, hey, they're not responsible for roof damage or defective work. That wouldn't make sense. Strategy number 3, agree to include a limitation of liability, but add a carve out for insurance and indemnity. This is a best practice when it comes to LOLs. Including that carve out helps ensure that the vendor's insurance coverage and indemnity obligations are not limited by the contract's liability cap. You want to have the full protection of their insurance coverage, and you want them to pay for their indemnity obligations and not have those limited by the LOL cap. This helps protect your agency's ability to recover damages up to their available insurance limits and for amounts they've agreed to indemnify you for. Contract verification. Agencies should ensure the carve-out is clearly defined and the vendor maintains adequate insurance. Strategy 4, limitation of liability with carve-out for required insurance limits and indemnity. So LOL clauses with carve-outs, they help balance the risk management with vendor financial capabilities in an effective manner. By promoting the requirement of the recovery up to specified available insurance limits in spite of what their total insurance limits are. So this is kind of capping the availability of the vendor's insurance only to those limits that you're requiring them to carry in the contract. So if they have a $100 million umbrella, but you're only requiring $5 million in the contract, that would be their limitation of liability at the $5 million. Now, this can be suitable for smaller vendors who maintain the agreed upon and required insurance limits, but can't accept unlimited liability. Strategy 5, this one applies more to larger, more financially resourceful companies. So what this is you set the LOL cap to equal their full available insurance limits. So this helps align the liability with the insurance. Setting the cap to their insurance limits aligns their liability with their insurance coverage, which ensures clear risk boundaries. And then matching the LOL cap with insurance limits simplifies your negotiations with that larger vendor by providing enforceable and consistent contract terms. Agencies need to verify the insurance limit sufficiently covers service risks to maintain proper protection. Now we're going to talk about our practice session. So let's get started with that. And as I mentioned a few minutes ago, the first clause we're going to look at here is all in the favor of the vendor. So we're going to practice de-risking that to be more balanced and then more in the favor of the public agency. So here we go. Limitation of liability. Vendor shall not be liable to customer for any indirect, incidental, exemplary, punitive, or consequential damages arising out of or
Hi,
related
this is
in
Kim.
any way to this agreement, including but not limited to lost profits. And then at the bottom, under no circumstances shall the vendor's total liability for any and all claims in the aggregate exceed the total amount paid by the customer to the vendor for the affected products and or support during the 3-month period preceding the event giving rise to the initial claim. There are a lot of, everything I've underlined here is a limitation, another limitation on this LOL. So here's how to go about making this LOL clause more in a public entity's favor. And to help you remember the techniques, remember the acronym MICE. So for the M, you want to look at making this provision mutual in both parties' favor. So that's the M's mutual. For the I, make sure you have the damages cap apply to individual claims rather than all aggregated claims. For the C, think of cap. So extend the scope of damages cap for the time frame that's available to be responsible for claims, or better yet, have no time limit. And then the E is exclude certain types of claims, indemnity, and insurance. So that's what I would call carve-outs, exclusions to the LOL clause. Here's an example of a balanced limitation of liability clause, where it's in both parties' favor. So neither party shall be liable to the other party for all these indirect damages, even if the parties have been notified of the possibility of such damages. Under no circumstances shall one party's total liability for any single claim exceed the total amounts paid by and owing by customer to vendor under this agreement. This provision shall not apply to either party's indemnification and insurance obligations under this agreement, a breach of either party's confidentiality obligations under this agreement, either party's gross negligence or willful, intentional misconduct, or 4, a breach of vendor's obligations under this agreement. So you can see how with the underlined wording, we're bringing this in and making it more fair and balanced, better for both parties. Now this last one is where we take the language and we put it in the public agency's favor. So vendor acknowledges and agrees that nothing in this agreement shall limit or restrict the customer, meaning the public agencies, rights or remedies available under law, including recovery of all direct, indirect, consequential or incidental damages resulting from vendor's breach, negligence, not just gross negligence, but negligence, or willful misconduct. Vendor's liability shall include, without limitation, costs of correction, delay damages, loss of use, and any other damages reasonably incurred by customer. Any limitation of liability or exclusion of damages shall apply only to customer's liability to vendor and shall not apply to vendor's liability to customer. So again, you can see how with the underlined wording, we're skewing it more in the public agency's favor. All right, now we are up to Q&A time. So I believe, Stacy, do you want to kick it off?
Yeah, absolutely. Thank you so much. There is a lot of information regarding limitation of liability, so we really appreciate you kind of putting that in context for us. And it's been very helpful. I'm sure there's going to be some questions. If people would like to drop their questions into the chat, or feel free to speak up. If you would like to just interject, feel free to raise your hand. I would like to start out the section by asking a question. We typically have a legal review process with our legal department, and they're pretty much they're covering all the contract except the insurance provisions. Risk management reviews all insurance requirements. And my question is, are there some sections of the contract that legal and risk management should jointly review? What has been your experience with this, and what you would say is a best practice?
Absolutely. Yeah, great question. And the short answer is yes, but I'll expand on that. So it is a best practice to have legal and risk management jointly review some of the sections in the contract, such as the indemnity, the limitation of liability, and the insurance sections of the contract. Why? Because this helps ensure that the insurance requirements are drafted to help support the indemnity obligations, and ideally to help ensure that any limitation of liability clause includes a carve out for indemnity and insurance, because that way the limitation of liability cap doesn't have the effect of capping the insurance limits or what the vendor's responsible for under the indemnity clause. Also, based on my experience working with lawyers over the years, I found out, shockingly, that most lawyers are not insurance experts. And most risk managers are not legal experts, but you wouldn't expect them to be. I'm sure being a lawyer is a full-time job, and it's a full-time job for me just keeping up with all the insurance changes. So it's a good idea to have a joint review of those sections, because it can help you to manage and reduce contractual risk. And I do want to mention one thing. I know I go into this in great exposition on my indemnity presentations. I just have to mention that there's two insurance coverages that can help support indemnity obligations in contracts. One is additional insured coverage. I'm sure all of you are familiar with that. The second one is contractual liability. So those are the two main ways that insurance can help support indemnity. And when I give a presentation to a bunch of lawyers on how to do contract review from an insurance and risk-related perspective, and when I mention that they should be looking at the indemnity versus like the apparent scope of additional insured coverage and making sure that those kind of line up, a little light bulb goes off in their head, and it's like, oh, that's why we need to look at insurance, because it's impacting the indemnity. And that's also always a fun moment. So thanks for the question. That was a great one.
Of course. Chris, are you seeing any questions out there? I don't see any at this time.
I did receive one.
Okay.
The question is regarding negotiations. And so many vendors argue that they cannot expose their entire policy limit to one client, and that's why they impose a LOL equal to the contract amount. Do you have any recommendations for responding to that position to try and move things along?
Yes. For general liability and umbrella and excess, you can require a per project aggregate, which will set up a separate limit that will apply only to that project. Depending on the size of the vendor, they may be able to get this for no additional premium, or more often their carriers will charge additional premium for it. But that's one way to help ensure that you have a separate pool of money. So even if the contractor or the vendor's general liability policy limits have been exhausted by payment of other claims, they still have that pool of money set aside to pay claims for that particular project. So it's a really good strategy to help protect from, losses. And I do know from working with a lot of subcontractors and contractors and vendors over the years, a lot of them don't want to provide access to their full policy limits because they say, well, that's not in our best interest because we buy those higher limits to protect our own company. So why would we want to just give you access to our full umbrella excess tower of limits? So I can see it from both ways. But you need to take into account very especially the risk of loss and the scope of work. Consider what could go wrong on a project. Obviously, something like painting a one-story building is a much lower risk than blowing up things with dynamite. So you have to kind of think about not just what damages, what losses could happen, but how the severity of them. Like, tunneling into underground work and having the roof of a cave fall in on the workers. You kind of have to think about what could go wrong and then make sure that you're requiring the right types of insurance to cover those losses. But that's a great question. And I see it from both sides. So if I was negotiating or helping a subcontractor or a vendor, then I would be pushing back on any requirements that require them to provide their full policy limits. And just stick to what's required in the contract. Another strategy that you could do as a public agency is if you're concerned about the limits that you want them to provide, then just bump up the limits that are required in the contract. That's another strategy rather than just asking them to make all of their insurance limits available to you.
Thank you. We have another question in the queue. Do you have any additional strategies specific to negotiating limitations of liability in software contracts?
Oh, with software contracts, yeah. When it comes to those tech or IP related contracts and also consulting and professional services, 9 times out of 10, you're going to be stuck with the limitation of liability because the losses involved, the potential losses could be really astronomical if you think about like a data breach situation. So for certain types of service agreements, such as IP and tech related and internet, related contracts, you're probably going to have a limitation of liability. And there, your strategy may be to, okay, we'll have a limitation of liability, but we want to set the cap for that to your full available cyber limit or something like that. That might help.
Perfect. We've ended up having to negotiate 3 to 5 times, maybe subscription fees within 6 months to a year, a period of time. That's been something that has come up on our end. We have another question. Oftentimes, as an insurer, we are seeing a contract after it has been executed. It can put a broker and a carrier in a position where we can be perceived as the bad guy for slowing down acceptance of the contract as is, and consequently the project. By trying to do the same thing, reviewing, do you have any recommendations for balancing out the stickiness of this kind of situation?
Yes, absolutely. I would encourage that the clients ask their insurance brokers to review the contracts well before they're near the end of or after contract negotiations. Because once a contract's been signed, there's not much that an insurance agent or broker or even a carrier can do other than try to match the insurance or try to provide insurance, often for additional premium, to help meet the contract requirements. But it is absolutely a best practice for all clients to get their insurance agents or brokers involved early in the process so they can look at the insurance requirements and some other benefits of doing this. Let's say you've got a subcontractor and maybe they need to get a per project aggregate, or maybe they need to get a railroad protective liability policy because they're doing work within 50 feet of a railroad. If they don't get their broker involved early, and they don't get quotes and find out how much it's going to cost to provide this insurance, and they just blindly agree to providing this extra coverage or additional policies, they're not going to have a chance to build those costs into their bid, which means at the end of the day, if they get that job, they could be in an unprofitable situation. I mean, I've seen railroad protective liability policies for like almost $40,000 on one job because most of it was near railroad tracks. And clients can be floored by how much things can cost. So they need to build the costs into the bids. But the brokers and the insurers, they can't get quotes for this coverage unless they know about the need. So, having good communication with your clients, knowing about these things up front, and then making sure that your clients get you those contracts with enough time to review them. That's another thing. Oftentimes when I first start working with clients, they might be used to sending insurance requirements and contracts over to their agents like right before the bid is due. Like that's the last thing they're negotiating. And I always shake my head because then you really don't have any wiggle room. You don't have any time to go do a good job on the review. You have no time to go get quotes and estimates on pricing. And if you wait till the last minute to send it to the insurance agent or broker, then, the other party might not be willing to make any additional changes to the contract. So it really hampers the broker and the insurers to be able to do the best job for the clients. So yeah, great question.
Okay, thank you. Another question just popped up. Would you ever recommend the public entity absorb the cost of premiums in the contract price in order to have the insurance proceeds available in the event of losses, damages? Discuss pros and cons.
Yeah, so that one is very subjective, and it really depends on what's going on with the scope of work. And maybe there's a situation when you're working with maybe a small subcontractor and they can't afford an endorsement or some coverage, or it's a high cost for them, but maybe they're the only source of that scope of work. Maybe they're the only sub that's doing that work or the only vendor providing a product. I mean, in some limited situations, I could see where a public agency could agree to either purchase the insurance if they have more clout and access to getting the coverage that's needed, or perhaps just paying the cost for the insurance. But I would say it's rare, those cases. It doesn't happen a lot, based on my experience anyway. I'm not sure what y'all have seen in that regard, but I would say it's an option, but it's not used very often.
Sounds good. Do we have any other questions? Would anybody like to go unmute and ask a question at this time? Okay. Seeing none, I think what we'll do at this time is we'll proceed to wrap things up. And in the interest of everyone's time, if you have any follow-up questions to this, actually, I just want to give you a minute, Noel. Noel has some tools that are available. I don't know if you can drop, I think you had it's like a 2-page or 1-page summary document of some strategies. Maybe we could drop that in the chat, or we can email it out to everybody afterward. And if anybody wants to get in touch with Noelle, I do believe she provides contract review training if your staff needs it, as well as, different consultations. So I just wanted to thank you again. If you'd like to add anything at this time before I move on, I'll just give you the floor real quick again.
Awesome. Yeah. So there are a number of ways that I can help you. And I do have a special rate for public agencies. So public agencies and nonprofits, if you do engage me to assist, my hourly rate for consulting is $250 an hour, where normally I'd be charging $350 an hour. So you get a nice discount if you do need to engage me for anything. Also, I sell insurance requirement templates. So if you're wondering what insurance you should be requiring of vendors or subcontractors, get in touch with me. I draft that type of language. Again, I will say caveat, I'm not a lawyer. So run it by your legal team before you use it. But what makes my templates super easy to use and user friendly is I give you two versions of them. So one has all the different types of policies and coverage and endorsements that might be needed for a particular type of contract, such as construction. And I gave you another version, and this one has internal only comments off to the side on every little piece of that language. It's like having me sit on your shoulder and say, now here's why this additional insured endorsement is important, or here's why you don't want them to have a cross-suit exclusion for insured versus insured, or something like that. So I can do templates for insurance requirements for use with downstream vendors and contractors. I can also put together checklists, which you can use as a reference if you're being asked to abide by insurance requirements by upstream parties. Public agencies, probably not so much. I do custom training presentations. I have tools on everything from like comparisons of additional insurance coverage and how it works to contractual liability. And I do, consulting as well. So some clients hire me to send over a contract. I'll look at the insurance requirements, redline it, send it back with my comments, and then they share that with their legal team and kind of move forward. So everything under the sun, but not from a legal perspective. So thanks.
Thank you. No,
And here's my
really
contact info.
appreciate that information for our group, because whereas like I represent a larger water utility, we have smaller water and wastewater utilities represented in our group as well, who don't always have the resources available. So knowing that this is available to them is definitely a benefit. So thank you, Noelle. We really appreciate your time, and I also would like to thank everybody who's on this call today. Without your participation and collaboration, we would not have this platform to have these important conversations as they specifically relate to us in the water industry. We hope that you will join us next month for our open forum discussion and continued conversations. As a last parting discussion, Vlad is going to say some closing comments. Thank you.
Yes, thank you so much, Stacy. Thank you, Noelle, for this very insightful presentation. It's a very important subject. It's very near and dear to my heart. I think you and I have talked about it quite a few times, and I believe that it's one of the most important clauses in contracts. I refer to it, which probably is not the right name, as a poison pill, because it can really undermine all the hard work that you put in when negotiating insurance requirements and indemnity clauses, and ultimately can nullify all your hard work that you put forth in that regard. So to me, it's a very important subject, and I think for our smaller agency members, I would encourage you to discuss it internally, bring it to your legal counsel, and if you would like to, as we usually do next month when we meet for our open forum, we will dedicate part of the meeting talking about this presentation and some of the takeaways and recommended actions that you could institute within your organization. As Stacy has mentioned, this is our last formal webinar of 2025. We will be meeting next month to talk about upcoming subjects for 2026. And as we always do, we will ask for your input to discuss what's important to you, what you would like us to research and present in the upcoming year. And as Stacy mentioned, we thank you very much for your time, participation, and support. We're very happy to have you as our members, and we're happy to be here for you. And just want to wish everyone safe holidays. and we will see you in the next year. Thank you so much for your time. And once again, thanks to our wonderful presenter and to Stacy for being such a great moderator. Thank you.
Thank you, Noel.
Thank you.
All right. Happy holidays, everybody.
Happy
Thanks.
holidays.
Thank you. Happy
Bye-bye.
holidays.